Good morning, everyone. It's Jenny Pakula, your General Counsel with the Oregon Association of Realtors. Thanks for joining us this morning for our webinar on omitted property, which many people may be asking, what does omitted property mean? Well, fortunately, we have Steve Anderson here today who's going to tell you exactly what omitted property means and how you can assist your clients when they're faced with an additional tax assessment. Steve is with First Class Properties. He is an appraiser for the Department of Revenue. Maybe technically I didn't say his title quite right for that, but he has property appraiser experience for the Department of Revenue. He offers his unique experience of being a former hearings officer for the Clackamas County Board of Property Tax Appeals. He has since represented taxpayers all over Oregon and Southwest Washington. Being involved in over 3,000 cases in the last 9 years, he has some well-tried advice on how to deal with the assessor. I think we can all use that. This class you're listening to today is a portion of Steve's bigger class. This class deals with 3 subjects which he plans to go into great detail on. Omitted property, which is becoming a bigger issue all the time, exception value, and the gross error statute. It's likely, as I mentioned, you've never heard of any of these topics, but they are causing problems, sale fails, and litigation statewide. Steve's delivery method is to mix in a few war stories and try to put some humor into a very dry subject that is woefully misunderstood by the public and realtors in general. We look forward to hearing from Steve, and as usual, everyone send your questions and Steve will take them throughout the presentation. Without further ado, here's Steve.
Thanks, Jenny. Morning, everybody. As Jenny mentioned, I do have some experience. I spent 4 years in Clackamas County in the Property Tax Appeals Board there as a hearings officer. Was involved in 2,000 decisions there in values ranging from a single wide manufactured home in Milano, about $4,000, up to including Clackamas Town Center, about $165 million. And so I've kind of seen it all, done it all, heard it all in that aspect. And since July of 11, I've been offering my expertise to the taxpaying public. And these 3 subjects that we're going to talk about, omitted property going to be in the first one, was not that big of an issue for me until about a year and a half ago. I was seeing about one of these a month. And now I'm seeing roughly 10 or 12 a month of these cases going on. And before we get into omitted property, what it is, I want to kind of give you a little background on the issue. First of all, the assessor is allowed by statute to assign any value on any property at any time for any reason. And you, the taxpayer, have to prove them wrong. It's one of the few situations I know in the United States where you're guilty to prove yourself innocent. Secondly, they all belong to RMLS. So we as brokers in our marketing advertising programs are offering 32 4-color photos, 286 characters of bragging about the property, if you will. Essentially, we're putting information in there that's trying to bring the buying public and interest into the property. Unfortunately, that also can create situations for our clients that might not benefit them financially through the taxing situation. Third, before 1960, I defy you to find a building permit locally to the permit issuers here in the state of Oregon. Before 1960, you might find a water line or a sewer line on record at some of these departments, but typically in 1959, if I was going to build a house or a commercial building, I could walk in with a cocktail napkin with a footprint of the property, write a check for 38 bucks, whatever it was back then, get a permit for the building, and then essentially they would just they'd staple the drawing to the permit until it was done and usually throw it away. They didn't care after it was built what was going on with it. So a lot of times the assessor doesn't know about certain property buildings that are on the property itself. And lastly, before 1971, below grade square footage in properties like daylight ranches, tri-levels, split entries, it was not considered to be living space. It's considered to be storage space because in the late 60s, builders here were notorious for building homes out with unfinished basements with the idea that the buyer could go in and stretch their dollar buying the house and then step in later on through sweat equity and build out the basement. And we as brokers come along 45 years later with 4-color photos of the man cave downstairs or the kitchen downstairs or the 2 full baths or the 2 bedrooms, etc. And the assessor sees that through their access to RMLS, and they go, wait a minute, we didn't know about this issue. And so they take a look at it and add that on. What omitted property is, the definition. Real market value is assigned every year by the assessor. It has been for like 55 or 60 years. If the property is being advertised at a value significantly higher, and significantly is their determination, I don't know exactly what that is, then the real market value, the assessor has a right to go ahead and assign the taxable dollars to that spread. Let's say you've got a $400,000 real market value assigned on the property. and we got a $600,000 asking price. That $200,000, that difference, that spread, if you will, is now taxable through the assessment process. And by the way, it's taxable for this year plus the prior 5 if the owner of record has been there for 6 years. So it's a 6-year event, and it can be quite costly, as you can imagine. If you're in Washington, it's a 5-year event. So this year plus the prior 4. And the process itself is very interesting. It's totally skewed, no R in that word, by the way, in favor of the assessor. You have 20 days from when they mail the letter to you, until 20 calendar days. It's not business days. From when they mail the letter to you to go ahead and take action on it. If you don't do that, you have to take them to tax magistrate court, which is an expensive and time-consuming process. I've had clients actually be on vacation for 2 weeks and missed the whole process. They got back, and then in their mail was the notice, and the notice already expired on this omitted property situation. Some of the problems we ran into, actually a lot of different problems regarding this issue. Situations where the sellers found out about the omitted property notice, paid the bill, if you will, before closing. It does not become a matter of record. It's not a tax lien because it's been paid off, and it does increase the taxes, and you don't find out until the following October when the bill comes. And the new buyer now steps into a situation where they bought a home based on a certain amount of taxes, and then the October statement comes and it's quite a lot higher. They have problems sometimes, making those payments because of the increased interest on, taxes on the property. Secondly, we have situations where they find out before the closing, and I've been involved in consultations last year, and about 100 of these last year. 7 of them actually resulted in sale fails because the situation was the tax increase actually triggered the payment to go up so much that the buyer couldn't qualify for the mortgage. Now you've got a buyer who's got earnest money involved in a transaction. They paid for an appraisal. They paid for a home inspection. They paid for a radon test. They paid for a sewer scope. They probably hired contractors to go out and look at, give them a bid on the deck, etc. They want all that money back, and they want to know who they can get it from. And a lot of times they promise their kids they're going to go to school in the fall, that certain grade school or high school. They want some pain and suffering money too, and they're looking at either the seller or the brokers involved. And we all have so guess who gets the phone call from the attorney? Usually it's us. That's one of the problems I'm seeing developing here. The statute says, the omitted property statute says, that the owner of record time that the letter is written is the one responsible for it. So if it's done after closing, the buyer gets hit for that year and that year only. The buyer is not responsible for any previous years unless they were paying taxes on their property. So that's what omitted property basically is in a nutshell. It's become quite a problem. We've had, like I said, I get probably, I don't know, every other day, every 3 days or so, I get an email or a phone call from a broker saying, what is this stuff? And unfortunately, until we had this class today, as Jenny alluded to earlier, you guys probably had no idea, no clue what omitted property was. And unfortunately, in the state of Oregon, the court system, ignorance is not a defense in the law. Okay, you have to be knowledgeable about this stuff, and I'm amazed at how many people call me and say, what is this stuff? What are we talking about here? So it's a big issue. It's becoming bigger all the time. There's very little pushback from the taxpaying public on this. The assessors have found, in my opinion, a very good way of raising additional revenue. And it's not based on a sale price. I get that question asked a lot. It's based on the asking price, and can be based on the asking price.
So, Steve, let me ask you, and you may get to this through at some point during the presentation. If a broker becomes aware of, they're representing the buyer, and they become aware of this additional assessed value before closing, what would you recommend they do if they still want the property but don't think the assessment is fair?
You can challenge it. First thing, I'd just identify all the parties involved and let them know we have a situation here with this going on, because that's a big issue. You can challenge it. It can be challenged in the 20-day period that we talked about earlier at the county, or you can actually take it to tax magistrate court. And if it does come up, I get this a lot prior to closing. I recommend you go ahead and pay the taxes. You can always go back and appeal them later. Paying the taxes is not an admission of guilt.
So how successful, in your experience, they move forward, close the deal, pay the assessment, the extra assessed taxes, and go back and appeal, typically?
It's case by case. I would say we probably don't. The other problem here too is the cost. Sometimes it exceeds the cure is worse than the cost. How's that? You got a filing fee with the magistrate court. You got to engage someone like myself to get involved. Usually I have to hire an appraiser to put value on the property to testify in court. It's not uncommon for us to have a $3,000 or $4,000 bill on the table before we even get to the courtroom. And then, of course, when you go to court, it goes up dramatically from there. But
is there a way for I mean, how can a buyer's agent find out about this before they close? Is notice always given to the seller, and it's going to be their, which brings us to a whole different issue
right.
of disclosure and other liability of notifying the buyer. But how typically would a buyer's agent find out about it before closing?
Well, if it's a lien of record or potential lien of record, title company should know about it. Okay, that's the first place I would go. And it's very important to have a preliminary title report and a final title report, because a lot of times it'll happen during that period where we have escrow open. That'll be going on. I've had cases, and I was sharing this earlier, in Clackamas County. They're notorious for putting on a lien with $0 amount, and let's say call us for the dollar amount. And it'll be on there for months at a time, and so we have problems with that. I had one case in July of last year where you love this story. The buyer had signed, the seller had signed, the mortgage company had wired the funds to the table at the escrow company. Escrow goes out to Oregon City to record, and they get there, and there's a little post-it note from the assessor's office saying, you can't record this till you pay us $8,600 in taxes. We haven't had a chance to mail this letter yet. By the way, here it is. Pick it up and take it with you, okay?
Surprise.
So, yeah, and I wasn't involved in this transaction other than I was just advising people. I had, I think, 7 people call me that day. I had people sitting in driveways with U-Hauls trying to move, and funds are being upheld because of the whole situation. So I told all the parties involved, record the whole thing. We'll go back and figure out later on what's going on here and who's responsible.
So typically, a buyer will get a preliminary title report once they purchase and escrow's open. Then you get these assessors going through MLS.
Right.
They see it, and then they file a lien.
Well, it's not a lien yet. It's just a notification that we intend to lien if we don't pay this bill.
Okay, right. Okay, so then then escrow title gets that notification, and in theory, they should immediately send a new preliminary title report to the buyers. Right. And are they doing that?
Not necessarily. And I don't really blame the escrow companies. It's funny that the assessor does. I don't, because they're going off information available to them to the public record. Okay. Some of the stuff is being discussed back and forth between the seller and the county, and it hasn't become a matter of public record yet. So it's really a gray area there, and so that situation goes on. Even worse, and I shared this with you earlier, is, and I had these several times, this happens where property's listed, you have a seller fill out a disclosure statement, and then a month or two later they get this bill from the county. They paid the bill because they don't want to hinder the transaction, and then maybe a month later they get an offer on the property and it closes, and the seller never thinks to go back and amend the original disclosure statement because it got taken care of, right? Okay. Well, the buyer is looking at this information from the disclosure statement, buys the property, and the following October gets a new bill, and it's dramatically higher than what it was the previous year when they settled, and they want to know what in the world happened here. And there is a little known, to answer your question too, Jenny, there is a little known situation where the counties are actually, when they know the transaction is taking place, they're supposed to due diligence, try to contact the buyer and let them know there might be a tax increase here. So I kind of hang that over their head once in a while, although they just kind of poo-poo the whole thing.
I'm sure.
Yeah, it's not their fault. You know, they didn't know. And well, you got it off an armless printout, and it said pending across the top. Gee, I wonder what's going on here, you know? So there is some accountability to the county also, and I've had them actually back off on some of the stuff because of that. But it has to be the right county, the right reason, and the right situation that to happen.
Yeah.
So.
Are we on the? I know we got a little sidetracked here with conversation.
Right.
Are we moving? Are we on the right slide, Steve?
Yes, we are.
Okay.
Okay. The ones that county collect the fees, either county collects it at escrow if it's closing, or they wait until the following October and put on the bill then. And I've got a case right now in Lake Oswego where the seller knew about it. Actually, I talked to the seller about it and thought it got taken care of in escrow, and it did. And the buyer got a bill for $4,000 added to their tax bill for this year. So the buyer wanted how it got through. I don't know what happened there, but we're working on getting that resolved. So, and yeah, the buyer is responsible for the current year only if it's a first year involved in the transaction.
Okay.
This is an example of a omitted property notice from Clackamas County. This is a property on the Tualatin River. Little story here. 1.7 acre parcel. In 1942, the owner at the time built a little 600 square foot cabin down by the river. I always want to play the banjo when I say that. And in 1990, the current owner at that time built a 4,000 square foot house up by the street where the utilities were at. And the bill you see is for 6 years, about $6,000. It reflects the value of the 600 square foot building down by the river. Actually, in the advertising on the property through MLS, the 600 square foot cabin became an ADU and had photos of it, and so this would reflect the $6,000 that the assessor hit him for taxes on that. Mr. Matschek, the owner, called me in November, I think it was, 14, was upset about this, and go scroll forward a couple pages here.
We've had a request for you to slow down a smidge. You're talking quickly.
I know I do. I'm sorry. I'm the oldest of 8 kids. In my house,
you got to talk quickly to be heard.
Yeah, that's right. One more.
Okay.
Okay, you'll see here, this is a tax statement from the property we're talking about, and you see the increase of the real market value by about 100 grand, and the assessed value also. That reflects the difference in value based on that ADU or cabin down by the river. You also see the real market value is around 630 on that slide, and I got a phone call from the seller on I think it was a Saturday morning. We talked about his situation. I have several questions I asked to clarify and qualify to see if this is going to be a case going forward or not. In his case, I asked the question, have you accepted an offer on the property? As a matter of fact, the evening before he did, for $645. Now, class, $645 is higher or lower than $630? It's higher, okay? So the offer, which is considered an arm's length transaction, basically makes the county's point. I told him, I'm sorry, I can't really help you here. Have a nice drink, write a check, and we're done. So that's what happened in that situation. Yeah.
So let me back up, and you might have said this on this particular example. So in 1 year, the taxes went up $1,500, almost $2,000, $1,700, and that was based on the new home, the 4,000 square foot home?
No, the 600 square foot cabin that the county didn't know about.
Okay.
Built in 1942 before building permits were required. Even though they have Google Maps and Google Satellites where they take pictures of all the roof lines and all that, for some reason they didn't see a 600 square foot building. Maybe it was under a tree or something. I don't know. So.
But as you mentioned, in this case, too bad, so sad. Given the sale price.
I couldn't do anything for him. That's what it boiled down to. And I look at this from every angle. Believe me, I know the rules and regs and try to take it apart so we can benefit the client. In his case, sorry, I write a check. And a lot of times I have that conversation with people. It's not a fun one to have. Yeah. But for you real estate brokers, I'm the one delivering the bad news, not you. So it makes you look good. How's that? They can't find me.
Sounds reasonable.
Next page.
All right.
Okay, here is a listing for a property in Lake Oswego. I got involved in this one. In fact, this is the one I alluded to earlier. I'm still involved with this one, the buyer on this property. You'll see the listing price is $1.15 million. If you turn the page. The real market value is how much, folks? $739 and change. Is that considered to be a significant increase in the value? I would say so. 400 grand is. And they got a bill from the county for, I think it was $18,000 for the difference for the 6 years between the 740 and the 1.15 million. The property actually sold for 1.08 million, which is a small reduction in the issue there. And this is a Clackamas County property. I got a phone call from the listing broker in late April. They were trying to close it on May 3rd, and what happened there was the county had actually notified the seller on November 10th of the previous year that they intended to go ahead and increase the valuation and obviously the taxes. And part of this process is they require a site inspection. They go through the property to verify their numbers, and also, by the way, look for additional revenue, additional value if they can on the property. So be careful when you let them in the property. That's what I'm trying to tell you there. They're trying to build their case for their value.
So how often do you see, I mean, it sounds like, I know this is just your examples, but in most cases for sale, the asking price is higher than the real market value.
Right.
I mean, but probably 90% of the time, right?
Typically in this marketplace, you'll see that. The other problem we have is that real market value is assigned the 1st of January every year. So I have situations where in September, it might be 20 months past that valuation date, and the market's moving along at 10% per year. You got an 18, 19% increase over that value just on the market happening. That wouldn't even trigger an omitted property notice. But in this situation, it did. And I contacted the listing broker was upset because they couldn't get a tax payoff from the county. They were trying to close within 10 days. Her deal was unraveling because of that. I contacted the assessor's office and tried to determine what the value was. We file many of these cases. We're pretty well known around the area here, up and down the state actually. So when I call in, I try to talk to people that don't know me there to get information from them, to extract information, because if I get my counterpart down there, typically it's more confrontational. And so in this case, I got a hold of someone there who was going to give me the number and put me on hold, and then she transferred me over to my counterpart who wanted to know I was doing this transaction. And basically I said, nothing yet, but if we don't get this resolved, they're going to probably hire me. We'll have to take you to court. They don't want to go to court, by the way, just to let you know. It's costly to them too.
So in the assessor's office?
Office, yeah. So I asked her, I said, why have you not assigned a value to this property yet, or a new value or a new tax? Well, they hadn't seen it yet. And I said, when did you ask to see the property? The prior week. So let me get this straight. You've had the lien for 5 months on the records with no dollar amount on her, and just now getting around to asking for access. Well, they've been very busy, she said, which I had a problem with that one. So I basically put together an inspection the following morning between the assessor's office, the listing broker, and the homeowner, and they got resolved and taken care of, and it got done essentially. And
so they are making this difference, assessed value, only on the asking price?
Correct.
So let's say the home sells, they send a figure, you owe this amount of money, home sells for $500,000 less. Too late, and they got to hire you and go appeal it?
We go back and clean it up, and take it
apart. What a nuisance.
It is very nuisance.
Why don't they just wait till it closes? Would it be easier for everyone, including them? Well, particularly them.
Because the statute says they have to notify the owner of record at the time they do it, and the statute also allows them to hit the homeowner, property owner, the current owner, for 6 years. If the buyer steps in, the transaction takes place, they can hit the buyer for that current year. So if they're financially advantageous, the assessor is, to hit it for 6 years versus the 1 year with the buyer. That's why they do that. That's why the statute's written. Okay.
Well, sounds like we might need to amend the statute.
We need. I think you're barking on the right tree there. Essentially, in this situation, we got squared away and taken care of. If you want to go back to the prior page, the listing itself, I want to show you something here. If you look at the bottom line of both public and private remarks, you don't want to throw the red cape in front of the bull, and that's what happened here. Note low taxes.
Well, okay.
Ooh. If I can give you guys a recommendation, I would not advertise in the brag box. I call it the brag box. Any kind of dollar amounts of improvements or the year they were done. And I want to E&O moment here for all you guys out there. If anything goes in at all, have the seller sign off on or initial off on any content there whatsoever. I've been involved in lawsuits where we've had brokers make representations of dollar amounts of improvements and years they were done, and come to find out the seller never pulled permits for any of that stuff. So, and I will tell you also, I get involved a lot in the tax side and the permit side issues of this situation, where work was not permitted or some of it was not permitted at all. I will tell you the tax problem is minute compared to the permit issue, because I've had jurisdictions actually go in and make people tear additions down off of houses or repair them to the tune of hundreds of thousands of dollars to bring them to current code. So
yeah, I'm guessing the assessors probably read these remarks too when they're going through the MLS rules, and that would be like a beacon light.
Well, yeah, when I highlight it in red, you give it to them that way.
Yeah.
So I interact on a daily basis with assessor staff people all over the state of Oregon. I mean, emailing or phone calling back and forth. And the staff people themselves are not bad people. In fact, it's kind of funny. They encourage me to do what I do because they think that there's problems in their system. They're lying around to kind of highlight or shine a light on the whole situation. And they share stuff with me they probably shouldn't about stuff going on. And they've been bragging to me about the last couple of years or so about the fact that Measure 5 is now 26 years old. Don McIntyre, the father of 5, passed away about 3.5 years ago. He's not around to defend 5 anymore. Measure 50 is 20 years old. Bill Sizemore, the lead person on that, is over in Idaho, I believe, selling carpet. He hasn't been around for quite a while. So the assessors have been going down to the legislature every 2 years in the sessions and chipping away at all the benefits to the taxpayers in these different ballot measures, to the point now where really all we have left is Measure 5 is the compression issue. And that's pretty much all we have left anymore. They even bragged to me about our Measure 79 back in 2012, the anti-transfer tax law. Okay, they told me that the realtors mind them of George Bush on the aircraft carrier with the mission accomplished sign behind them, to walk off in the sunset like it's done. And if you ask me, this is really the whole thing we're talking about right now is very, very close to a transfer tax. We don't, I mean, it has a whole lot of, if it walks like a duck and talks like a duck, that's what I'm trying to tell you here.
Yeah, of course, they're permitted under statute to do it right now, but you're right.
Right.
They're a different form.
It's different form, but
Yeah.
it's kind of the same thing. So.
All right, here's a question for you from someone. Can we back up and discuss the requirement to tax on the lower tax assessed value regardless of current RMV? I don't know if that's a question.
It is a question. I'm not sure I understand.
Clarify.
Yeah, could you clarify that question? Because the assessed value, I think what they're asking is that, this is another misnomer we have. We're kind of going off track here, but everybody thinks that the taxes go up 3% per year, and the assessed value does go up 3% per year automatically. The problem is, or unfortunately, if you look at any of the ballot measures or levies or bonds that are passed on local jurisdictions, those are all tied to real market value. So when you vote for a school levy or a library levy or a road situation or whatever, those are all attached to real market value, not assessed value. So I get that question a lot, especially from realtors. Well, it's 3%, right? No, it's not usually 3%. It's usually whatever the market's doing, because the real market value follows the real market.
Which I guess you just answered this next question. If there are not additional improvements, how does the assessor justify raising the assessed value more than 3%? That's automatic, right?
Okay.
3% standard?
Right. Where real market value and assessed value are two different numbers. In the case we just talked about, where the real market value went up like 100 grand in West Lynn, the assessed value at a certain point also. We're getting off track again, but we can talk about this. What the counties do is they have what's called CPR, Change Property Ratio Index. We're getting away in the weeds here now. But under CPR, what happens is you take one property category in the county. Let's say it's residential property. Let's say we have $5 billion in real market value in Lane County of residential property this year. And let's say we have $4 billion of assessed value in that category, in that county for this year. You'd have a 0.8 multiplier, which means that if I add $100,000 of improvements to my house in Lane County, the assessor would add $100,000 to my real market value and $80,000 to my assessed value. That's how it works. Those numbers change by category, by county, by year. There's like nine different categories in each county. So how it works. Now you're getting really off on the wonk stuff here, but that's fine.
Oh.
This is what I do on a daily basis.
Oh boy.
So, all right. Anyway.
Okay, it's complex.
It is. It is. So in this situation here, getting back to my train of thought here, the assessors have bragged about the fact that they're able to go ahead and influence, I like to use that word, the legislature, and they don't have a whole lot of pushback from anybody. And so one of the things I've been doing in my classes, and maybe Jenny doesn't care to hear this, but I'm trying to get our organization to become more involved, if you will, as being the guardians of I call it the hen house here, of the money. And I know that OAR and PMAR have their own stuff they're working on, and I'm trying to get the awareness out there to realtor public, because I think we need to be more involved in this. And you guys react to what we asked you to do. Well, we haven't asked you to do this yet, so hopefully we can get more in line with that.
Yeah, this statute may have been on the books for a long time, but it's really only recently surfaced to be a problem, at least in the Portland area, and it sounds like it's happening statewide.
Right.
So, of course, OAR is definitely the defender of private property rights. We will work on this one as well, but it takes a village, and Rome wasn't built in a day, and
Right.
You know how quickly things move through the legislature. They don't. Quickly.
While I'm on the subject also, there was a bill introduced in the legislature. I believe it's in our coverage here.
Next page.
House Bill 2080, which did not pass, thank God. But I want to make sure you guys understand it's still being talked about. Maybe it's not in there. Okay.
I think you, yeah, well, here you
Yeah, House Bill 2080 here. Okay.
Yeah.
House Bill 2080 would back up a minute here. Real market value and assessed value are on the property every year, your taxes, okay? Real market value is usually the higher of the two. The assessed value is the lower of the two. House Bill 2080, if it was brought through, and they're going to keep trying this one, would reassign the assessed value in the following year to the sale price. So essentially, you'd have a tax increase based on every transaction that took place, in my opinion.
So it'd be automatic.
It'd be automatic. The following year, the new assessed value would be the sale price from the previous year. Do the math, folks. That's not going to be financially.
It's a lot of revenue.
It's a lot of revenue.
For the counties,
okay.
huh?
They're also talking about in the 17th legislature, they're bragging about they want to introduce a bill that would allow them to do this on any transaction on the property. For instance, if you refinance their property, the mortgage amount is higher than real market value. They'd be able to do the omitted property notice on that basis, just by having that information in there. So they're getting very aggressive at doing this, and they're bragging about the fact.
Did you say the mortgage value? So
Yeah,
someone's loan?
Yeah, if you refinance your house,
Yeah, right.
and on your tax statement, it's going to show the new mortgage balance. Okay.
Yes.
That mortgage balance is higher than the real market value. That
Wow.
would allow them to go ahead and do the 6-year adjustment based on the taxes.
Gotcha.
So, so I'm a little concerned there because that could trigger a lot of activity. And once again, as I mentioned earlier in this class, Oregon is the only state in the country that doesn't have the reset on sale clause that the other states do regarding valuation. If they
Explain what that means.
Well, basically, every other state in the country, California, Washington, if the property transacts, the county is allowed to go ahead and reset the real market value the following year to the sales price, the previous year, time adjusted actually to the sales price.
And
Oregon does not do that.
Okay, when you say we can do that, but we haven't. I mean, but it's not automatic under statutes like in other states.
The statute does not allow the assessor to do that.
Oh.
And they do it anyway to what we're talking about right here.
Okay.
So, and if they want to do that, that's fine. Let us vote on it. We haven't done that yet, though.
Well, here's a super good political question that well, how does the assessor justify going back 6 years when we were still in a recession then and the values were much lower?
They trended back. They do that. They don't use the same number going back. If you got a $700,000 valuation, they go back by year by whatever the trend was. And as long as it's higher than what the real market value was that year, they have the right to go ahead and tax that spread, whatever it is. I agree with what the questioner is asking. I was on the board 6 years ago when we were dealing with 18% reductions in property values across the board. But that's how it works.
And did you explain the process on how they determine RMV?
Real market value? Yeah. Once again, here we go off in the weeds again. Okay.
Okay. Sorry. If we digress too much, then skip it.
You have more information you ever want to know today about this issue. Real market value is determined by what they call neighborhood trending, market trending. The counties are divided up into market districts. There's about 300 per county here locally, and those districts include everything. I mean, there'll be a residential category. You might have, there's actually, in Multnomah County and Clackamas County, Washington, there's actually a district called gravel pits. There's one for mobile home parks. There's one for several for industrial. But for simplification purposes, they have the residential properties divided up into different market districts that have market commonality. Now, I'm not sure what that means. That's a big word that they use on me all the time when they tell me this stuff. But anyway, so you might have 300 to maybe 5,000 homes in one of these market districts. And what they do is they being the assessor, all the sales for a calendar year in that market district. Let's say your average sales price was $400,000 in your neighborhood, and there's 14 sales in 2014. And juxtapose that to 2015, there were 11 sales, and average sales price was $440. The assessor would say, okay, we have an indicator here of a 10% increase year to year. So in the 2016 real market value, we'll adjust all the properties in that district by 10% up. It's a long way around the barn. That's how they do it. Okay.
So it would behoove you to actually own a home. If you own a large home, own it in a district where there's lots of smaller, less expensive homes. They're doing the average?
Or in an area where the values aren't going that much. And I'll give you an example. We have right now in Portland, inner northeast, inner southeast, it's white hot. Multiple offers above asking price. Typically I-5 out to say 39th or so, or excuse me, Cedar Chavez is very, very active marketplace. And we're seeing double-digit increases year to year in valuations there. I go out to Gresham, the same county, same values on those houses out there. I'm seeing 4, maybe 5 or 6% increases in the values there. So the taxes on the inner northeast, southeast properties will go up dramatically versus the Gresham tax would go up that much because they're tied to RMV in a lot of cases. Same county, same market, but different valuations because of the different neighborhoods we're talking about.
Right.
Okay.
Got it.
Hopefully answering the question the questioner had there.
Well, I think you're probably giving our members enough information for them to spot red flags and call you or someone similar.
Here's a situation too, as a real estate broker. This is a big one. You go out on a listing appointment, and before you go, hopefully you pull the tax report on the property and the title report on the property and look at it. And if you go out and the tax guy has it down as a 3-bedroom, 2-bath, 1,200 square foot home, and you walk through the house and it's 4 bedrooms, 3 baths, and it's like 2,000 square feet, I would hope you can know the difference between 1,200 and 2,000 feet while walking, okay? You have a problem, because when you put it in the computer with the photos on it, the assessor's going to see that. And so we have an issue now. We have 800 square feet of found property.
Which happens all the time.
It happens all the time. That would trigger a minute property notice too. Right. That's another basis for that happening.
Yeah.
So
not to mention, do they send it to like a different agency to check for building permits?
Yeah, and that's usually the biggest problem. We actually had a case a couple years ago out in Boring, Oregon, where we had a 2,000 square foot home on the market for quite some time, and a little pickup showed up in the driveway with a Clackamas County sticker on it, and two guys got out. The guy on the left, the driver, was the assessor, and the guy on the right was the building codes division. Okay, and they walked up and said, "What's going on here? We have 1,200 square feet in our card down at the office, and you got 2,000 square feet you're advertising." And what had happened was someone prior to this owner had gone through and added on a bedroom and a bath, a master suite essentially, without permits. And so long drawn out process, got involved. All I'll tell you is this: there was 2 checks written for around $200,000 to make it right. So, and the brokers weren't real happy. The property never sold, by the way. It's just a matter they found out about it. So.
Yeah.
So be careful.
Yeah.
Be careful.
Yeah, and it seems like obviously, if you're doing an addition, you should follow the proper building codes, right. But nobody wants to pay more than they have to, and it only matters till you go to sell your property. Then it really matters, and that's when you're going to end up paying for it anyway.
Yeah. Let me share you, while we're on the subject, a couple of things that happen too. I've had several cases where this happens, where the buyer buys a property, everything's hunky-dory, they don't think anything's going on. I had a case a few years ago in Washington County. The gentleman bought the home, actually was an attorney, and Daylight Ranch home. He bought it in 2002. That was quite a while ago, 14 years ago. In 2013, he got a bill from Washington County for omitted property for $3,820 because in the 2002 RMLS printout, 11 years prior, there was a quote in her updated kitchen. And so they hit him for $3,800 for the omitted property for that kitchen that was updated after the house was built. He called me up. He wanted to sue everybody in sight. He's an attorney. It doesn't cost me to go to court. And I said, before we do that, let's talk about the filing fee, $252. You have to engage someone like myself to get involved. I'm $1,500 upfront retainer and something like this. I would have to hire an appraiser for 6 years on a kitchen. That's $2,000. We just spent $3,800, and guess what? I don't know if we're going to win this case or not. So I don't recommend you don't even take it on, because the likelihood of us winning is probably pretty good. But once again, as I told you earlier, the cure is worse than the cost.
Yeah.
Have a drink and write a check.
So do they automatically, and when I say they, the assessors, do they automatically assume that the market value has increased simply because someone has remodeled their kitchen? Because that could just be some maintenance, maybe. They got rid of the avocado green.
Well, you're going to the next subject we're going to talk about here. Okay.
Okay.
You're segueing
All right.
here. I'm not ready to segue yet. I'm almost there.
Okay. Fair enough.
Okay. But no, that's a good question. And to answer your question also, if they can't find an improvement in the property, I love this one, and the courts hate it. They use what they call AR, which is assumed remodeling. We just assume you did something to the property, create that value that is not there, and therefore it falls under our category of AR, which the assessors love to hang that tag on a lot of stuff. When it goes to court, I've had a magistrate judge actually tell the county, assumed remodeling to me is like taxing air. You can't do that, okay? So it doesn't exist, and you can't tax it. So
which judge was that, so we can jurisdiction shop?
Unfortunately, it doesn't work that way. It's round robin. You go in, okay? You're too far there. That's the last one.
Okay.
All right. Next. Are we done with the omitted property?
If you say so.
Okay.
Questions? Okay. Anything you want to wrap up on those?
No.
Questions?
Exception value. Topic number 2. Get involved in this a lot. What happens on exception value is the assessor is required on the 1st of January every year to put a value on the property, real market value on the property. They sign it actually 12:01 a.m. on January 1st. Now, if you haven't seen the pickup in your driveway with a guy with a camera out there that time of the night, they do it, pardon my French, they do it by computer, okay? That's how they determine these values. But anyway, that's when it's supposed to be put on there. So, for instance, let's say I'm doing a remodeling project on my home, and it starts in October and finishes in March. Okay, I don't have the total improvement on the property yet, do I? I have it maybe half done. So what happens is the assessor takes the improvement done till the 1st of January and adds that on. The balance of whatever's left over is being put on the following tax year. That's what's called exception value. So we know it's there. It hasn't been attached yet, but it's coming. Okay, it's out there, and so it's a matter of record, quite frankly. So how is it determined? They go off the improvement values of the property. When is it used? Typically, like I said, every year they add it on when they can. And essentially, the biggest problem I'm seeing with the exception value, and I have dozens of these cases I'm working right now, it seems like I get rid of a couple and a few more come in. It's not so much the property owner, it's the contractors who do this, but when you pull permits for these improvements, the final permit, the occupancy permit, you have to go down and put down your improved value, not the total project value. And what I see contractors do, they'll throw everything, they'll throw in the drop boxes, they'll throw in the porta potties and say this is all the project, it's $200,000. The assessor says, thank you very much, adds on the rolls, and the following year, taxpayer gets a $4,000 increase in their taxes over, this improvement. And so they call me up, and I go through. I usually ask for a scope of work from the contractor, and I'll look through there and see things like replace existing sidewalk or existing driveway. I replace the water line or the sewer line. Painting inside and out, carpeting, roofing. Typically, if it's an improvement in the roof, you got a problem with that. But if I got a comp roof and I replace it with a comp roof, that's the same thing. Decks. If I have a deck out there, it's deteriorating, I replace it with a like quality, like size. Fences, same thing. If I have dry rot, wet rot, and I repair that. If I take EFIS siding off, put hardy plank on, folks, those are all maintenance. Those are not improvements. You don't pay taxes on maintenance. And unfortunately, a lot of these cases, I'm seeing half, if not more, of these remodeling projects are maintenance issues, not improvements. And then the taxpayer gets stuck with this, like I said, maybe a $4,000 increase in their taxes. It costs them at least that in my situation. I get involved to get that cured, and the courts do it. And we do a lot of these, and they're very time consuming. There's a lot of moving parts here involved in this situation to get to it, but it does happen. And so if you want to be a hero, if you do a blog to your clients, or if you do an email blast or a newsletter, I would include this information there because you'll be a big hero to your clients, because usually it's not the property owner doing it, it's the contractor doing this. And oh, by the way, if the assessor doesn't like your dollar value, they'll assign one anyway, and they do it all the time. I have a client right now in Oregon City. 2 years ago, he built a house. He had a contractor build a house for him, I'm sorry. The appraised value was $583,000 for the mortgage. The county had a value of over $800,000. We got it lowered to the appraised value. He just hired the same contractor to put 3-sided building, I think it's a hay storage building is what it is, on his property. With permits, profit and overhead was $9,810 was the cost. Clackamas County has assigned a $28,000 value to that building already. So we're going to fight that one next year. It's coming up under this situation.
Wow.
So,
all right, here's a question. What about when the assessed value is higher than the purchase price?
You have a basis for an appeal.
Windfall?
You have a basis for an appeal for your property tax appeals board, yeah. Or the real market value, typically too, in most cases.
All right, should we carry on?
Yes. Okay, gross error statute. The good news is coming. Finally got the good news. Okay.
Yay.
ORS 305-288 says that residential properties 1 through 4 units only, if the real market value assigned by the assessor is 20% or more above the actual market value of the property, you have the right to appeal for that year plus the prior 2. Okay. You have to go through magistrate court to do it. Once again, the filing fee is $252. You will be required through the magistrate court process to allow the assessor onto your property for interior inspection. One of the conversations I have with clients about this situation is, do we have something on the property we don't know about? Is there a man cave that wasn't permitted? Is there an outbuilding that we don't know about? Okay, because they're going to be there. And they can, in this situation, add value and add taxes in tax court. So be careful when you go through this process, because it can actually bite you. And we file a case in magistrate court. The magistrates, there's 3 of them. They have different calendars. Usually it's 6 months to 12 months. It's time frame to get one of these resolved. I don't have control of their calendars, obviously, and I'm dealing with a county and a court. So I get people wanting all the time, what's going on with this case? Well, I'm waiting for something to get back to me. It's a slow, drawn-out process. But the nice thing about this process is, by statute, you are entitled, if you win, to your overpayment. It's not a refund, by the way. It's an overpayment. You just paid too much in taxes, you silly taxpayer. Overpayment from when you paid it, plus 12% per year interest on that money when you paid it. So even though I filed a case in February of 2016, I'm maybe doing this year, last year, and a prior year, and it takes a year maybe to get this thing worked out, I'm getting interest on that 13 money at 12% per year. So that's pretty fast. And I'll tell you this, we're the largest filer of this cases statewide. We've filed dozens of these cases. I have not been in a courtroom since March of 2014, almost 2 years on one of these cases. The judges kind of know now we file a case that's got merit. We turn down one of these cases we actually take because we go through a pretty thorough, intake process in this situation because it's your money. We're concerned about it. And we have a good reputation with the courts. We don't want to sully that either. But by doing this, they pretty much tell the counties, look, Anderson's filed a case. It's probably got merit. Negotiate with them. And they really want to talk about them being the judges. They want to talk about U.S. Bank Tower, Washington Square, the HP campus in Corvallis, maybe the wind farm up the gorge, maybe even the Google farm over in Moscow County. They don't want to talk about a 3-2 ranch in Eugene. They have to by law if we pay the filing fee, but they don't want to. So that's what it boils down to. And when the counties are told by the courts to negotiate, it puts my client in a pretty good position to work something out with them.
Nice.
So that's what we typically do. We get involved in these cases all over the state of Oregon. We've had them pretty much, I think 14 counties I filed one of these cases in so far, and we've been successful in all of them. Do we guarantee results? No, but I haven't lost one in 2 years, so it's not a bad situation to be involved in. And I've included, I believe, some checks for you to get a taste of this. Here's one. Maybe a check, I'm sorry. Funny story on this one. Serious money, by the way. Bill is the former CEO of Precision Cast Parts. Bill drives a Ford pickup, kind of a, average Joe, so to speak, average Bill. His property is on the confluence of the Tualatin and the Willamette Rivers. It was built by Jerome Kersey. You might know that name. Jerome, when he originally built it in 1997, had 17 acres there. In the year 2000, Jerome sold off 6 acres adjacent to his property to a guy named Brian Grant. You might know that name. Brian built a home in 2000, and Brian had it for sale for 3 years. Couldn't sell it. Finally sold for $3.2 million in February 2014. I was searching through, which I do a lot. My staff does this also, the records. And his $3.2 million sale, I juxtaposed that to his real market value by the assessor of $4.95 million. I wrote to Steve Lemma, the buyer of Brian Grant's house, a letter saying, hey, you have a basis here for a 1-year appeal. You might want to give me a call. He did. And we ended up saving him almost $14,000 from the BOPT appeal on that property. Well, Steve, the buyer of Brian's house, and Bill, the buyer of Jerome's house, share the same driveway. And I got a phone call, I'm going to say April last year, from Bill. And I will use his words, not mine. I saw Steve's check. I want some of that county cash. Can you help me? And so I looked in his situation and realized he was a 3-year appeal. He was a gross error statute appellant because his valuation was roughly the same as Lemma's property next door, but he had a valuation of over $5 million from the county. And so we filed the appeal on his behalf with the magistrate court. As I told you earlier, these cases take a while to develop. You've got a county and a court involved. And we filed dozens of these cases every year. And all my other appellants, typically maybe every month or so, they'd send me an email and saying, hey, what's going on? What's the progress in the case? And I'd send them back, waiting to hear. Bill's case, every other Friday afternoon, I got a phone call. And it was something to the effect of, well, let's say I gave you a retainer. I haven't heard from you in 2 weeks. Are you in Vegas, Rio, or Miami for money? What's going on? And I don't know if he was joking me or prodding me or whatever, but I just feel like, nothing's happened in the last couple of weeks. I'll get back to you when something does. And then this check came into my old office on Friday morning. I think it was August 6th. So I called Bill up. I said, Bill, your check's here. Great. How much is it for? And when I do these cases, I try to ballpark the savings for people. And in Bill's case and in Steve's case, neighbor next door, I had a problem with this because they both have 5 acres of wine grapes on their property, which is a farm deferral. In order for me to come up with the exact dollar amount, I have to go down to Clackamas County Assessor's office and pull the actual annual jackets and look at the valuations and how they did that. And as I mentioned earlier, I'm very popular with the assessors. I'm in their office a lot.
Yeah, yes, and so very popular.
So when I go into an office, I get a little posse around. I get people with cameras and stuff taking pictures, and et cetera. In fact, I call him Assessor Ozzy when I go in there. Anyway, I didn't do that for that particular reason. And so in Bill's case, I told somewhere between $40,000 and $45,000 to be my projected savings for him on this situation. And I told him the check's not what we talked about. And I started to elaborate. And he went off on a tirade. Now, I've been married 35 years. So I know when someone yells, someone listens, it's called a conversation. So that's what we had for about 2 minutes. And we discussed my real estate brokerage license. We discussed his attorney. We discussed my parentage several times. And finally, he was going to hang up on me and call his attorney. I said, Bill, don't do that. Let me tell you how much it is. And so I told him. And the amount obviously was more than I projected. And so there was dead silence on the line. And he said, well, when can I get it? And I said, I'll mail it to you tomorrow. And we took care of that. I tell you that story to tell you this one. I had a project up on, no, it's nothing there to talk about. It's not there, okay? Sorry, Jenny. There's a project up on Skyline Boulevard above the zoo called the Skyline Condos. It was a two-building apartment complex built in the 50s that was converted to condos back in 2008. Since 2009, there's 25 units there. Since 2009, the highest sales price in that project is $149,500. The county, Multnomah County, had those valuations between $221,000 and $283,000, real market value. I was contacted by one of the owners. He came up to do a presentation to the HOA. 9 of the owners signed on with me. We did this same appeal that we're talking about here, the gross error statute, and they all got checks between $4,000 and $7,000. I'm as proud of those people, what they did, as I'm Bill's here. Obviously, Bill I made more money on, but that was the situation there. If you'd have told me in 2014 that I'd be appealing $140,000 condos at magistrate court, I would have laughed you out of the room. But that's what happened here. So we work in all different kinds of price ranges. It is available to people across the board.
So I'm going to go out on a limb here and say that I believe the assessors might disagree with everything you're saying, right? Fair enough. So if let's just play devil's advocate here. You file these complaints, when are the assessors, obviously they respond, give examples of where they've been successful and you haven't been.
In this case? Or
in your bag of war stories.
Well, we had one. We got it reversed. We lost my last magistrate case I was in court on 2 years ago. We lost the case in a coin tower condo, and we took it to tax court, which is the appellant, and we won there in the following year, which was I think was decided in September of last year. So it's been a while since I lost a court case. Then again, you got to understand something. I'm very careful of the cases I take to court. Mm-hmm. I've lost cases, don't get me wrong, but it's been over 2 years since we lost one. And before that, some of the cases I took on, it was different situations, not so much this situation, if you will.
Yeah. So you must review a good number of complaints mm-hmm. or potential cases that come across your desk. Mm-hmm. And I know you talked about one client you couldn't help, the ADU fella.
Right.
Do you have any other examples of where you've reviewed some cases and you're like, no, you're going to lose the assessor. We cannot beat the assessor on this one. And under what circumstances?
I've got a whole file in there of cases I turned down this year. There's probably 100 of them in there, not more. Different reasons.
Yeah.
For instance, if people buy a home from a bank or foreclosure or short sale, that's not going to be a basis for an appeal. They think it is. It's an arm's length transaction in their mind. And the statute says that if the market segment is not 20% or more of the market, it can't be considered. In our market right now, bank influence sales are about 6% of the market, so that's not going to be considered at all. I have clients who call me up. They buy a home from their grandfather or mother or whatever. It doesn't count. It's not a true arm's length transaction. We have other situations where properties are distressed. They buy it distressed and they want to go ahead and get something done, and they're work on the property at the same time. You might get a 1 year reduction on the property taxes because of that. It's going to go right back up. It's called cost to cure. If I got an EFIS siding situation, let's say I got a $200,000 problem with siding because doorways and windows and all that are affected, I can get the value lowered for 1 year. But when you go back and do all the work, you have to put the value back to where it was at before. So it doesn't stay there. It can't stay there. I hope that answers your question maybe a little bit there.
Yeah. Yeah.
So,
and I know there's probably more examples than we could ever come up with where you're not going to take the case and because the assessor's correct.
We turn down more cases than we take on. And for you real estate brokers, we're here as a resource for you because a lot of times I can tell your client no, explain to them why. And like I said, make me the bad bear here, not you. And you get the the relationship to with your client going forward.
Okay. What else you got for us, Steve?
If you haven't heard enough from me yet, tomorrow at 4 o'clock every Thursday from 4 to 5 p.m. on KBMP radio here locally, 1410 a.m., the money station. I have a show called the Property Tax Avenger. It's a live call-in show, 227-1410 if you want to call in tomorrow.
Well, nice shameless plug.
Nice shameless plug.
Good. That was good. So what I'm thinking maybe for part 2 in this omitted property increased tax discussion, we have I don't want to use the word debate, but I imagine it could get contentious. Have an assessor or two.
I'd love to.
Oh, perfect.
I'd love to.
Excellent.
Yeah.
Well, then you assessors who are sending your questions, you're going to get your day in court, so to speak.
And what's interesting, and I hate to interrupt you there, I've had assessors, I do this class for RMLS. I've had assessor staff people actually attend my classes, and they've told me they're amazed, probably because I talk so fast, that I can get out so much information in an hour and a half. It takes them twice as long to get that conveyed to the clients. And they told me my basic class is a 90-minute class. I cover everything. They're surprised I can cover the whole gamut in 90 minutes. So, which is a backhanded compliment, I guess. But I've had that happen before too. You'll find most assessor staff people that I work with, we're not, buddies, beer buddies and all that, but we have a pretty good relationship going back and forth.
Yes. Yes, it's like any adversarial relationship. Sometimes you get along, sometimes you don't. And so okay, well,
I have one more thing.
Yeah, no, go ahead.
The last thing in
we're done early. You guys are going to consider it a little CE bonus for you. We're going to and see, because Steve talks so quickly, which I will work with him on in the future. So we apologize. Some of you may have to go back and listen to the recording, which will be available, and you can hear every word. Slow it down, stop it. So sorry about that.
I've been asked to wear weights in my tongue. How's that? That works. Okay. Anyway, the last thing I want to talk about is the last page of the handout is my certificate from the Department of Revenue as a property appraiser.
I don't know where it went.
Is it
after questions?
It should be before questions. That's the front there.
Okay, bear with me, everyone. I'm technologically challenged.
I think it's in the handouts portion.
Right here?
There, at the last one right there. There it is. Okay, there it is. All right. I want to talk about this a little bit.
What do I do now? Jake, how do I get it?
I got it.
Okay.
You got it?
Yeah.
It's right there. Okay, thank you. All right. I want to talk about this. And I want you guys to understand something and make it clear to you. Big problem I have here, and you should be concerned about. In the Portland area, the 3 counties in Portland, there are over 560,000 tax accounts that this year will pay right at $3.5 billion in taxes. Let me finish this thought before you start asking questions here, okay? There are less than 100 people in the 3 counties combined to make the value decisions on all those properties. They do it by computer trending, we just talked about earlier, market areas, that kind of stuff, all right? Of the 100 people I told you about, less than 10 hold a current fee appraisal license. They hold this kind of license here from Department of Revenue, RA1, RA2, property appraisal on PA1, PA2, or PA3. There are no certified appraisers that I know of in 3 counties locally, which means they can't actually do an appraisal for a residential property over $1 million. There are no MIA appraisers on the commercial side. There's 22% turnover in the people every year that do this for a living. Do you see the problem I'm seeing here? Okay, a lot of inconsistencies going on. That makes my career in this field look very good right now because of that. But I got this license April of last year. I'm one of 2 people, as I understand it, that have this license. Doesn't work for a government entity. I'm required by statute to have 60 hours ongoing ed to keep the license active, which means I get to go to classes with the assessor staff people and the assessors. I've started a GoFundMe account for my Kevlar vest, my helmets I'll need when I'm there. And it's kind of fun when I go to these classes because everybody's looking at me like, what are you doing here? The adversary, so to speak. I'm the fox in the hen house. I've been offered jobs because of this certificate, $3,708 a month as an appraiser for the Department of Revenue. Didn't want to take the job in Cottage Grove. Thank you very much. But and it's interesting to me. Our firm has extracted over $1 million in refunds for taxpayers in the state of Oregon. 5 years have been in business, well over $1 million. The assessors aren't mad about that. They're mad about this because I'm in training with these guys at the same time. I mean, they're actually in getting their how can I say this, in their bloodstream in this situation. It really offends them I have this license.
Ooh, I know that's going to send some of you appraisers in a tailspin that are listening, or assessors in a tailspin. But as I mentioned, you'll get your opportunity. We're going to have a debate. This is a perfect opportunity for you all to come to the OAR convention in Sun River this fall. We can do an hour and a half at least, back and forth. It could be very heated, and this one I'd love to moderate between you, Steve, and the appraisers. And I appreciate Steve's healthy dose of confidence in this arena. He's obviously got some experience, and of course, even the best attorneys or people who want to be attorneys don't always win. So It happens. So, okay, we got a hypothetical someone sent here. See what you got.
All right.
Home built 2006. Shop built 2011 with permits. County appraised property in 2014. Shop still not showing on the records. What is the concern?
Oh, omitted property, big time, for at least 4 years. Yeah.
Okay,
since 11, yeah. I'd be worried about that. What big one? I'm surprised they don't have it because typically, like I said, they buy Google aerial shots of everything. I'm not sure which county we're talking about here, but usually they own that stuff, and then it's pretty much up to date. I had a client in Oregon City a couple years ago who, kind of funny story, called me up out of the blue, and they jacked his taxes by almost $3,000. He had built in 1991 a huge shop without permits under a huge oak tree. And the previous year, the oak tree blew over in a windstorm, and so the Google satellite went over and took a photo of that. I think it's 36 by 60 shop's what it was, and basically the county assessor got a hold of, saw the roof line, measured out, sent the bill for that building that wasn't on their rolls, and he was upset about that and wanted to take them on. I go, if you build a shop that they didn't know about, there's probably something else in your property they didn't know about either. Don't go along with this, because if you do, they're going to come out to your property and probably find more value to add at the tax court and actually increase your tax than we're talking about right now. So,
yeah, it's a double-edged sword, isn't it? It really is.
And you asked me some cases I turned down. I turned that case down because I just looked at it and go, you know what? How do you deny the shop's there? It's there. You build up permits, and I'm surprised that the permit people haven't come out to you now for the permits on the whole thing, because that'll be very expensive also.
Right.
So be careful what you ask for.
Yeah, exactly. Like everything in life.
Yeah.
All right. If there aren't any other questions, or Steve, if you don't have any additional comments you'd like to make, we're going to wrap it up. And again, we got done a little earlier, and I think that's because Steve speaks so quickly. But stand by for part 2, because we clearly have some folks who might want to present a rebuttal position, those employed by the county.
Bring it on.
All right. Well, the challenge, the gauntlet is thrown. We'll be back. All right. Thanks, everyone. Have a great day.
Thanks, Jenny.